Let's talk about the legal process in the average criminal case in Texas. So starting with an arrest, usually you'll be taken directly to the jail. In Dallas County, that's the Dallas County Jail. Every county has its own jail. Sometimes, if you are in a particular city that has its own city jail, you might be taken to that city jail only to be transferred to the county jail later on. In some circumstances, if the police are wanting to try to interrogate you or interview you, they might take you to the actual police station to attempt to interview you first. And then if either after the interrogation or if you turn them down, then they would take you to the jail. Once you get to the jail, you should go before a magistrate, which is a type of judge, for what's called arraignment within the first 24 to 48 hours. Arraignment is when you are formally told what criminal allegations you are being held in jail for. The judge will then determine what an appropriate bail is in your case. So bail is the amount of money that you would have to put up in order to get out of jail pending your case being filed and then ultimately being resolved in court. Bail can be either what's called a cash bail, which means if the bail is set at $10,000, then you pay $10,000 in cash directly to the county, directly to the court. The upside of a cash bond is that there's no bondsman, there's no go-between, there's nobody to check into, and at the end of the day, as long as you haven't violated bond, you're going to get all of that money back minus a $50 processing fee. The downside, of course, of a cash bond is it's expensive. If your bond is set at $10,000 and you don't have $10,000, cash bond is not for you. The next type of bond is called a surety bond, and that is when you go through a bonding company or bondsman. Generally, you're going to pay roughly 10% of that bond. So that $10,000 bond would mean you pay $1,000 to a bondsman, and that bondsman then posts the bond on your behalf. The upside here is it's far cheaper than a cash bond. The downside is you're not going to get any of that money back at the end of the case. And most bondsmen are going to require that you check in with them and report to them throughout the pendency of you being on bond. The third type of bond is reserved for lower level cases, and that is a personal bond, sometimes called a personal recognizance bond or PR bond. And that's simply a free bond where you are being released based on your promise and your promise alone to come back to court and follow all the rules of the court. Once either you bond out or if you can't bond out, you stay in jail until the case is actually filed and ready to proceed. So the way that works is the police department is going to submit that case file, all the evidence, all the police reports, witness statements, 911 calls, videos, etc., to the prosecutor's office, the district attorney's office. And they have an intake division that will review the case and decide whether or not they are going to proceed with prosecution of your case. If your case is a misdemeanor and they decide they are going to proceed, then the case is filed and ready to go. If it is a felony, then the prosecutor must then present it to a grand jury whose role is to determine whether the prosecutor has enough evidence to move forward. Grand jury hearings are closed door hearings, meaning they happen behind closed doors. Generally, you don't get to be there. No one is there. It is just a summary of the evidence to see if the prosecutor has enough evidence to move forward. Hiring a good attorney early in your process is a really good idea, possibly because they can intervene and get the intake prosecutor to reject a case. Or if the intake prosecutor has accepted it, they can argue to the grand jury as to why the grand jury should reject the case, sometimes called a no bill or a no bill dismissal. So getting an attorney involved early on can have really good outcomes for you. Once the case is filed as a misdemeanor or filed and indicted as a felony, it will get its first real court setting. I say real court setting because sometimes counties will have an estimated court setting, or sometimes called a bulletin board setting or an initial appearance. The idea being when you are first arrested and taken to jail, the court system has no way of knowing if your case will even be filed, or if so, how long it will take. So they, not wanting you to fall through the cracks, will set some sort of initial court setting. And if you are out of jail on bond, then you're expected to check in, to come to court if you don't have an attorney, and see if your case is filed. And if you do have an attorney, and this is another good reason to hire an attorney early in the process, is they can tell you whether your appearance for that is waived, and they can check on that case filing for you. Once you get a real court setting, the same thing applies. Every court has different rules about whether you are expected to make an appearance at every court setting. So a good attorney who has knowledge of that court system and that particular court will be able to tell you, yes, you do need to show up, or no, you don't need to show up for every single court setting. And then, of course, when you do have a court setting, tell you where to go, what to do you need to check in with a bailiff or not, or just simply wait outside. Every court has particular rules, and your attorney can advise you of all that. Once you have actual court settings, the defense attorney can get access to all the evidence in your case under what's called the discovery process of a criminal case. So most discovery is online now, and so I can simply log in, get access, download all the evidence, and begin reviewing it. By Texas law, as crazy as it sounds, I can't give you or anybody else copies of the discovery, but of course, I can go over all the evidence in your case with you, bit by bit, page by page, or summarize it for you, whatever you need to have a full and complete understanding of your case. And then, whether it's one court setting or 20 court settings, the next part of the process to try to negotiate an agreed settlement of your case. Maybe that's convincing the prosecutor to dismiss the case, or offer you some sort of pretrial diversion program or conditional dismissal. Maybe it's a plea bargain. At the end of the day, if an agreed resolution cannot be reached, that is when a case is set for trial. And the default is a jury trial, a trial before a jury of your peers. But if both sides, both the defense and the prosecution, waive the right to jury, then a trial can be had in front of a judge. I know it's a lot of information, but that is the legal process in a criminal case from beginning to end in Texas.